So I have already made a lot of people as co-hosts. So please keep on admitting people, those who join. So very good evening, all the participants. Today we will discuss some of the questions which were asked recently in CA final examination. Because one of the chapters in CA final is IBC also. So I asked one of the students to send me the questions and he has sent me some questions. So let us try to attempt and see to what extent we can solve those questions. So the first question is that Oman Incorporated HUF filed a petition. So the first question, whether HUF can file a petition?
Yes, sir.
Yes, sir.
Any person.
Okay. So any person can file the petition, but it should be against the corporate person. If it is under part 2. So Oman Inc. filed a petition under section 9. And who can file a petition under section 9?
Operational credit.
Operational creditor. And who is operational creditor?
A supplier or service provider.
Right. Who is a supplier of goods or service provider? For initiation of CIRP against delimited corporate debtor. So this application will be covered under which part? Part 2 or part 3?
Part 2.
Part 2.
Right. The adjudicating authority admitted the petition wide order dated 26th September 2022. So within what period the adjudicating authority should admit the application normally?
14 days.
Yes, so 14 days. And initiated CIRP and appointed PS as an IRP. So IRP is the insolvency professional who takes care of the company from the date of commencement of this insolvency till a resolution professional is appointed normally in the first meeting of COC. Subsequently, PS IRP has been replaced by SKA resolution professional on 10th of January 2023. The insurance of the assets of the CD was lapsing on 16th of December. The IRP recognized the urgent need to get the insurance renewed in order to safeguard the assets of the CD, decided to take new insurance policy at a higher premium rate, comparing the previous insurance policy without the prior consent of the COC. Because at that time, there was no COC, since he was IRP only, and the RP was appointed in January, I think. IRP was appointed on 10th of January. So, on the date when this insurance policy was taken, it was lapsing on 16th December. So, IRP recognizing the urgent need to get the insurance renewed in order to safeguard the assets of the CD, decided to take new insurance policy at a higher premium, comparing the previous insurance policy without the prior consent of the COC. The IRP entered into the contract with the insurance company for taking the new insurance policy. Now, whether this action is correct or not, this is the first question. Now, what is the question they are asking? They are asking whether PS, the IRP, has the authority in entering the new insurance policy. This is the first question. What is your view on this? So I think for this, for answering this question, you have to see the powers of IRP vis-a-vis the powers of RP. So the powers and duties of IRP are given in which section? One is the section number 17, Management of Affairs of Corporate Debtor. So let us try to find out whether in section 17, so any such thing is given.
Sir, he can do it, and subject to ratification it at COC.
And let us see section 18 also, duties. So whether anything regarding preservation and protection of assets is given under the powers of IRP or not?
Yes, sir. So there's a section, I guess, just give me 1 minute, which talks about management of corporate debtor as a going concern. And
This is section 17. No?
okay, just okay. So because what I figured out was that I'll take section 20 where they talk about that the IRP is supposed to make every endeavor to keep the corporate debt as a going concern in order to preserve the value.
So
And
where
then
it is
therefore,
exactly written?
oh, do you want me to read the section, exact section?
Yes.
Section 20, subsection 1.
Section 20 says management of operations of the corporate debtor as a going concern. So the IRP shall make every endeavor to protect and preserve the value of the property of the corporate debtor and manage
sir.
the operations of the corporate debtor as a going concern. So if we see, he has to make every endeavor to protect and preserve. And the insurance policy, it was lapsing on 16th of December. At that time, there was no RP. So he had to preserve and protect the value of the property of the corporate debtor. So this action of IRP was justified.
Sir, it will be ratified in the first COC meeting.
Yes, everything is subject to ratification by COC.
Sir, one more thing, it asks about this value policy at a higher value. Does it have any relevance in this one?
Actually, sometimes as the period goes on, as the asset is depleted, so normally the insurance value also increases. So we have to see whether what was the reasons for increase in the insurance amount. So maybe that the asset was more older by 1 year. So that is maybe that due to that reason the insurance price was hiked.
Okay, sir.
So the answer will be that it is governed by section 20 subsection 1. Because whatever answer we give, we should try to justify it by way of citing the proper section or regulation. This way we can revise the concepts also. So IRP has to protect and preserve the value of the property of the corporate debtor. Now another related question could be, what if the COC doesn't agree? COC says that okay, we will ratify only up to the insurance amount which was paid in the last year. Then he has to give his justification. He has to approach the insurance policy and they will have to see. He can say that okay, let us approach the insurance company and let us see whether it has been increased for all or it was increased in this particular case only. And ultimately, if the COC doesn't agree, then what are the options available to the IRP? The IRP either has to bear on its own or he can approach the adjudicating authority, because ultimately he can seek directions from the adjudicating authority that these were the circumstances. I was the IRP, there was no COC, there was no RP, and there was an urgent need. So considering the urgent need, I got the insurance renewed. That will depend upon the amount also. What is the amount involved? Anyway, so IRP was well within its right as per section 20 subsection 1. Now let us see the second question. Now in this case, MN has granted an interest-free loan to AB Private Limited with a condition to repay the loan within 3 years. AB Private Limited, they defaulted to repay the loan. MN filed a petition under section 9 of the IBC to initiate CIRP against AB Private Limited. After complying the required formalities, the adjudicating authority dismissed the petition on the ground that it is an interest-free loan and the applicant is not a financial creditor. And another question was, identify the date of commencement of CIRP. in relation to CIRP initiated against D Limited. So what is the date of commencement of CIRP in this case? The date of commencement of CIRP is 26th of September 2022, the date when the adjudicating authority admitted the petition. So in this case, there are two questions basically. The first question is whether loan can be granted without interest.
Yes, sir.
Yes, sir.
We have already seen this point, I think, while discussing the definition of financial debt. And
Yes,
the
sir.
definition of financial debt is given in section
Section
5.
5, subsection 8.
Section 5, subsection 8. So section 5, subsection 8 says,
Oh, so it says that it
yes,
is defining financial debt has a principal term stating a debt along with interest, if any,
if any,
which is
yes.
disbursed
So
against the
yeah.
consideration for
So
time
it
value.
could be there, it could not be there. So if any. So if any itself implies that it can be without interest also. So there is no infirmity in case the debt is given without interest. Another point is that this petition was filed under section 9. So whether section 9 is the correct section or not?
No, sir. He has filed it accidentally in section number 9, which is for operational creditors.
Yes. Yes.
But this is financial debt, therefore, it's a financial creditor. Section
Right.
7.
So in this case, what the adjudicating authority will do?
So they will, I guess, they will reject the application and give him a time of 7 days so that he can put another application.
No, once
Or
the
they'll just-
application is rejected, then he has to file it anew. So there is no question of, actually it is a basic defect basically. So he has to file a fresh application. This application, because defect, actually there could be definition of defect also. What type of defects could be removed? So defects could be, say, an affidavit is not attached or the proper documentation is not there. So those could be the defects. So if there is a basic defect, suppose this application is filed under section 10, so they will straight away throw this application. So in this case, the adjudicating authority will reject this application and they will ask him to file a fresh application. I think normally the registrar itself will not admit, because there is a registrar attached to the NCLT and the registrar office itself will not admit this petition. So the rejection of the petition made by MN on the ground mentioned above is valid.
So, but there's this trick part where they say that we are rejecting this applicant because he's not a financial creditor. So does that mean the adjudicating authority is incorrect for stating that since it's a loan without interest, it is not a financial debt and therefore you are not a financial creditor? Is that what the question is saying? Because that's where I was confused.
Actually, they are saying that actually these are all descriptive type of questions. So these are not MCQs. So we have to explain in detail. These students, they are expected to explain these things. But if we boil it down to this question, whether the adjudicating authority should admit this application, so adjudicating authority will not admit this application because it is filed under wrong section. It should have been filed under section 7. The first question is whether there can be an interest-free loan. The answer will be yes. Second is whether the section under which the application was filed is correct. The answer is no.
One question over here on 5.8. So actually the definition says, while it says means a debt along with interest if any, which is disbursed against the consideration for the time value of money. So when they are saying time value of money, that means there has to be an interest, no?
No. It need not be there. Actually, there are many cases. Suppose a holding company is giving loan to its subsidiary company. So in that case, there are other considerations also. So it need not be, interest need not be there in every case. There could be considerations other than interest also.
Because all the examples given from under 8, from A to I, all of them actually have an interest element or something else other than an interest element.
No, that is there, but it could be without interest also. There are decided the
No,
cases.
could it be, actually, I was thinking, could it be that the debt also includes the principal as well as the accrued interest,
No,
which
no,
is
no,
unpaid?
no. That is different. Financial debt is different.
No, financial debt, that means the principal as well as the accrued interest which has not been paid. So
If
that is
any,
the,
if any, they say no. Financial debt means a debt along with interest, if any. So if there is any interest. But there are decided cases where it has been held that even interest-free loan can be given, and they give the example also of a holding and subsidiary company. Suppose a holding company is giving loan to a subsidiary company. So whether it will be a financial debt, the answer is yes. So whether it can give loan without interest, the answer is yes.
I had a doubt regarding interest.
Yes,
So एक बार CRP का एप्लीकेशन मैंने डाल दिया, तो
right.
क्या अभी भी ये जो पूरा CRP का प्रोसेस रहेगा, ये 180 डेज, अब भी मेरे को इंटरेस्ट मतलब मुझ पे लगता रहेगा या वो रुक जाएगा वहीं पे जितना मैं?
No. Actually, you have to file a claim. So in the claim, you will claim up to the insolvency commencement date. So you can charge the interest up to the insolvency commencement date. So they will not take into account the interest which has accrued after the insolvency commencement date. The bank will go on charging, but because it is basically the resolution, it will depend upon the resolution applicant. Okay, to what extent he is ready to pay. Normally they are expecting a haircut even the amount up to the insolvency commencement date. So what to talk of the interest after the insolvency commencement date. So that will depend upon actual terms and conditions. But normally the claim has to be made up to the insolvency commencement.
Okay, sir. And in case a resolution plan is rejected and there is commencement of liquidation
So
and
then
fresh
he
claim.
has to again file a claim form and he has to charge interest up to liquidation commencement date.
Okay.
Right.
Clear, sir.
Hmm. Now, second question. After approval of an application made by the financial creditor for initiating CIRP against the corporate debtor, the COC has been constituted. So, in this case, there was an application by a financial creditor and now the COC also, application has been admitted and COC has been found. So, now the financial creditor wants to withdraw the application. So, the first question here is, who can withdraw the application?
So the person the applicant.
Yes.
Applicant.
So only the applicant has the authority to withdraw the application, whether or not COC has been constituted. Even if COC has been constituted, only the applicant has the authority to move an application for withdrawal. It is another thing that approval of COC also is required, but it can be filed only by the applicant. Thereafter, the financial creditor wants to withdraw the application, but is not willing to put forth the justification thereof. So whether any justification is required if he wants to withdraw the application, or he can just file without any
Justification is only
justification.
required when expression of interest has been published in Form G.
Right. So justification is required in only in specified cases where invitation for expression of interest has already been issued. Because in such a situation, the things have moved to an advanced stage, and naturally there should be justification because lot of expenses have been incurred. So will he succeed under the provisions of the IBC in this case?
Yes, sir, he will.
Any other thing you would like to add? Because COC has been constituted. So COC has been constituted, so he has to
He has to take approval of COC.
So RP will put it before the COC. And what is the time by which COC has to decide?
7 days, sir.
Within 7 days of the receipt of
application withdrawal.
And once they approve it with say 90% vote share, then within how many days the RP should put up the application?
3 days.
Yes. So these are the things which are given in 12A. So section 12A, if we see, so all these things are given in section 12A, read with regulation. And what is the related regulation for this?
I'll have to check, sir. I forgot.
Withdrawal is given in regulation number 30A. So you have to read section 12A along with regulation 30A. Withdrawal. Whether any bank guarantee has to be given here or not? Whether any bank guarantee is required to be given by the applicant? Suppose this financial creditor is withdrawing the application. So whether he has...
Yes, sir.
Yes. Of what amount?
So I haven't gone to the amount. I don't know.
Any other participant?
Estimated resolution cost. No?
Yeah. So estimated expenses incurred on or by the IRP, and rather estimated expenses incurred for the purposes of clause AA, A, B, C, and D. Now AA says fees payable to AR. So if any AR was appointed, then the fees also it should cover. Then out of pocket expenses of AR. Then expenses incurred on or by the IRP and expenses incurred on or by the RP. So fees and expenses basically of IRP and RP and AR have to be covered by way of the bank guarantee. So this also we have discussed. Now it says referring the applicable provisions, decide whether the contention of the... Now 3. Mr. Samuel D'Souza submitted his candidature for being a resolution applicant of ARC Chambers Limited in persons of an invitation made to prospective resolution applicants under section 25(2)(h). So Mr. Samuel, so he wants to become a resolution applicant. RP is Ashok Taylor. Now Samuel is a spouse of sister of Vincent, who is going to be involved in the management of ARC Chambers. So whether this Samuel and Vincent are related parties or not, any idea?
I guess so, because under related party, sister and sisters, as in sister's husband or brother's wife, they are also come under relative.
So for this, which section we have to look for?
Sir, 29A.
No. Section 5, subsection 24A. For relative. For relative, first of all, we have to identify whether this person is relative or not, whether Samuel and Vincent are relative or not. So this is given in section 524A. It says relative of the individual or a relative of the spouse of the individual. And relative means and then it says who is a relative of the individual or a relative of the spouse of the individual. So
explanation B gives that. Wherever the relation is that of a son, daughter, sister, or brother, their spouses shall also be included.
No, he is a spouse of sister of Mr. Vincent. So basically,
So the related party is the sister.
right.
The
So
spouse is also
our
included.
spouse will also be covered. Yes. So both are relative. It is another matter whether this fact is relevant or not. Sometimes in the case study they give irrelevant facts also. So when we read it further, we might find that this fact is not relevant, or maybe it is relevant. Let us see. But we have established that they are related. If we want to use it, we can use it. Who is going to be involved? So he will be a connected person basically. So if we see as per section 29A, so this Samuel D'Souza and Vincent, they are connected persons. because he is going to be involved in the management, and he will be a connected person as per which clause of 29A? 29A J2. Any person who shall be the promoter or in the management or control of the business. So he will be covered here. 29A J2. Anyway, now let us see further. And Mr. Samuel D'Souza, being a person resident in India, was also convicted under FEMA. So he was convicted under FEMA, which is, they have already given, it is given in 12th schedule. And the imprisonment for 12th schedule is how much? As per 29A. What is the minimum imprisonment?
2
It is
years.
3 years.
2 years. It is 2 years or more. It is given in 29AD, 29AD1. And only 1 year and 3 months have expired. So there is a proviso also which says that this clause shall not apply to a person after the expiry of a period of 2 years from the date of his release from imprisonment. So he was released only 1 year and 3 months. So this period also has not expired. So he is ineligible under 29AD. Who? Samuel D'Souza. So Samuel D'Souza cannot become a resolution applicant as per 29AD. For not paying penalty arose due to bringing into India from Canada during his temporary visit 2 crores worth Indian currency notes. In the light of the given facts, examine whether Samuel D'Souza is eligible, whether he is eligible or not.
No, sir.
So he is not eligible. And whether this fact of Vincent is anyway relevant for this study or not. Because we did not make use of it. But let us frame another question, whether Vincent can be a resolution applicant. They could have asked. Now the question they are asking is whether Samuel can become a resolution applicant. Now another question they could have asked is whether Vincent could be a resolution applicant. Any idea? Because Vincent is a connected person under 29A J2. But this clause of conviction is not applicable to a connected person, which is referred to in clause 3. But it is not covered under clause 3. It is covered under clause 2. So if they ask you a question, whether Vincent can be a resolution applicant, what will be your answer? Any idea?
Yes, why not? Because Samuel D'Souza is not being selected as the resolution professional.
No, my question is whether Vincent can become a resolution applicant.
But he
Because-
isn't a related party, no?
Look, connected person is okay. But first of all, only connected person who is not eligible under A2I. But he is eligible because he was not convicted. Vincent was not convicted.
But he's a director.
Huh?
He's a director, no?
Mm-hmm.
Vincent is going to be involved in the management of
No,
art
that is
chambers as
true.
a director.
Yes. Mm-hmm.
So he cannot be involved then.
But it says na holding company, subsidiary company. As this clause 29A(d) is not applicable to person referred to in clause 3 of explanation 1. Now clause 3 of explanation 1 says holding company, subsidiary company, associated company or related party of a person. Now is a related party of that person. So what is your idea? Whether Vincent can become or not become? Now the fact is Samuel has been convicted and this person is a connected person of Samuel. But I think this connected person clause will be applicable only when the main person is not eligible. So this main person is not eligible under A2I. Now, what is your idea on this? Suganya?
If I go to the 29AC, it says that at the time of submission of resolution plan.
No, leave it. 29A-D. 29A-D we have to see now. Convicted for imprisonment. Because here the point is conviction. So the facts of the case are the Samuel has been convicted and Vincent is the related party. Vincent shall be the promoter. So Samuel and Vincent are connected persons. So the question here is, but they say that clause 3 will not be applicable. Clause 3 of explanation 1. And clause 3 of explanation 1 says relative of connected person, related party of a person. But he is not a related party. He himself shall be the promoter, basically. So I think Vincent will also not be eligible. Because if there is a relative of Vincent, then he will be eligible, but Vincent will not be eligible. Because the exemption in clause 3 is to relative or related party of a person who is connected to any one of these. But there is no connected person. He himself shall be the promoter. Vincent himself shall be the promoter and he is a connected person. So I think both Vincent and Samuel will not be eligible. Anyway, we can discuss it further in the group. But I think Vincent will also not be eligible. But suppose there is third person, say Thomas, who is a relative of Vincent. So then Thomas will be eligible. Because he will be covered by explanation 3. Clause 3 of explanation 1. Now next. Members of the committee of creditors representing 49% of voting rights placed a proposal before the resolution professional for inclusion of a particular proposal relating to realization of some assets of the company. As we know, there has to be a quorum in the committee of creditors. So what is the quorum?
33%.
33%. And naturally, when they sit together, so they may give proposals. So the proposal could come from a single person. The proposal could come from a person who is representing 33% or more. So there is a difference between these two. So when the proposal is coming, suppose this proposal had come from a member of the committee who represented 10%, then what will be your answer?
Oh, so such proposal, if I feel is not appropriate, would be rejected if his proportion is less than 33%.
Yeah, so it is up to the discretion of the RP.
Yes.
Let us see the related regulation for this. This regulation will be in the committee of creditors. Yes. So the related regulation will be regulation number 18, sub-regulation 3. So regulation 18, sub-regulation 3 says, a resolution professional may place a proposal received from members of the committee in a meeting if he considers it necessary. So may place a proposal. So what used is may. And shall place. So there are two situations. First is may, when he considers it necessary. So there is no percentage. And shall place the proposal if the same is made by members of the committee representing at least 33% of the voting rights. So here the proposal is given by members of the COC representing 49%. So he is under an obligation. So he has to shall. The resolution professional is of the opinion that the proposal given by the above members will result in delay in the CIRP and therefore does not want to include the proposal for discussion. Referring to analyzing the applicable provisions and the relevant rules, advise the resolution professional whether it is mandatory for him to place the proposal. So what is your answer? It is mandatory. So we will say, please go through regulation 18, sub-regulation 3. So this way we are able to again revise the regulations. And these are very simple questions. Please remember this. Now next, Lock Limited is the corporate debtor under CIRP. Two resolution plans have been proposed, one by Key Limited and second by JL Limited. Lock Limited has a financial debt of 100 crores and it owes the following amount to the members of the committee of creditors. So FX Limited, GHU Limited, Key Limited and QW Limited. Now let us open an Excel sheet for this. So this is the Excel sheet. So here, who are the creditors? So creditors are FX, GHU, KEY, and last is QW. So these are the four creditors. Now, what is their debt? 30, 25, 20, 25. So total debt is 100. So total debt is 100. So now, suppose there is a proposal of key.
So what you get away with that, if the team will be used as oxygen, then there's no pressure, then there is the credibility given, even.
So proposal of key limited. And second is proposal of GL. So proposal of K Limited. So it was
75%.
25, then 20. So these are the three persons who have approved this proposal. So 75. Now second proposal. GL. First party agreed to the proposal. Second also. Third did not agree. And fourth. 25. Just a minute. Yeah, got it. D2. So whose proposal will be selected? Because there was a voting.
JL Limited.
So proposal of GL Limited will be selected because suppose this GL Limited also got 75%. Then what will happen? Suppose we change the figure. So in this case, let us say that okay, instead of this, so what we'll do? So this party agrees. So in this case, which proposal will be selected? If this is the scenario, then which proposal will be selected? So COC agrees for a tiebreaker formula in this situation. So they agree for a tiebreaker formula, and as per tiebreaker formula, the proposal which is there, so they might have divided certain criteria that okay. So we'll, in case both the parties get the same votes, both the resolution applicants, then we will go as per the tiebreaker formula. So this is given in where it is given. Voting on a resolution plan. Any regulation for this? This is given in regulation number 39. So regulation 39 talks of approval, and they have given an illustration also. So in case both the resolution applicants, they get the same votes, then the committee shall approve either plan A or B as per the tiebreaker formula announced before voting. Okay. So now let us again go back. So voting results they have given, and we have already seen the results. First question is whether the resolution applicant can attend and vote on the resolution plan. Because in this case, what we have observed is that the resolution applicant is also the financial creditor. So first question, whether financial creditor can become a resolution applicant.
Yes, sir.
So there is no bar on the resolution, on the financial creditor becoming a resolution applicant. Because Key Limited is also a financial creditor and he is a resolution applicant also. So the first question is answered in the affirmative that okay, resolution applicant can attend and vote on the resolution plan. Whether he can attend all the meetings or he can attend the meeting only in which his plan is being discussed.
All the meetings.
No. He can attend only the meeting in which his plan is being discussed. And where it is written? Any idea? Where it is written? Yes, anyone?
Oh, so section 30.
Section 30. So section 30, subsection 5 says the resolution applicant may attend the meeting of the committee of creditors in which the resolution plan of the applicant is considered, provided that the resolution applicant shall not have a right to vote at the meeting of the committee of creditors unless such resolution applicant is also a financial creditor. So here the related section is section 30, subsection 5. And the regulation was, which regulation was there? Regulation number 39. Regulation 39. So we have to see as per this. Now next question. Decide the resolution plan that can be considered as approved. So here the proposal of GL will be considered. Now let us see this question. Mr. Kush is an operational creditor. So he filed an application with the adjudicating authority to initiate CIRP against M Limited, and the application was accepted. On 10th July, NCLT Delhi appointed Mr. Ajay to act as IRP. After the appointment, Mr. Ajay issued the public announcement on 12th July of the initiation of CIRP process and called for submission of claims. On 20th July, the committee of creditors was constituted by Mr. Ajay. Thereafter, Mr. Kush wants to withdraw his application. So the first question is whether an operational creditor can withdraw the application. Under section 12,
Yes, sir.
whether,
No.
huh?
Sir, I guess yes.
Yes. So they can twist the question. So they may say that whether operation, so then you might feel confused whether operational creditor can. So any applicant basically. So whosoever filed the application, whether it be financial creditor or operational creditor, they can withdraw the application. However, Mr. Ajay, now let us go to section 12A also. So whether the CD who filed the application, whether he can withdraw the application. CD. Suppose CD filed the application under section 10. Now he wants to withdraw. Can he withdraw?
Yes, sir. On
It
approval
is
of
mentioned, yes.
Yeah. So it is given in the section itself. The adjudicating authority may allow the withdrawal of application admitted under section 7 or section 9 or section 10 on an application made by the applicant. So there is no confusion. So the applicant can withdraw the application, whether it is 7, 9 or 10. Now here, Mr. Ajay is IRP. He denied filing a withdrawal application stating that COC has already been constituted. Now referring to the provisions of IBC, answer the following questions. Number 1, is Mr. Ajay right to deny Mr. Kush to file a withdrawal application with NCLT Delhi?
no, sir. No, Mr. Ajay is wrong because
Right.
the operational creditor before the commencement of before the constitution of COC can also withdraw an application by giving it to the IRP, where the IRP has to give it to the adjudicating authority within 3 days. If the COC has been commenced, then he has to take approval of COC. Within 7 days, the COC will decide, and after 90% approval, they will give it to they will submit the application to the IRP, where the IRP has to submit it to the
Right.
adjudicating
Perfect.
authority.
So would your answer differ in case the COC is not constituted? Who is the authority to pass the final order of withdrawal application? So who is the final authority to pass the final order of withdrawal? Adjudicating. So adjudicating authority is the authority to pass the final order of withdrawal. So in both the cases, operational creditor can file the application. Only when COC has been constituted, so they have to approve with 90% majority. Now next question. So here, let us see, as at 31st March, XYZ Limited had the following debts. So financial debts, 200 lakhs. Then B, creditor B, 250 lakhs. This is a related, C is a related party, not regulated by financial sector regulator. 150 lakhs. D, operational debt, and E is operational debt. So total debt is 1000 lakhs. So now you have to form the COC. Due to impact of heavy losses and liquidity crunch, XYZ Limited could not pay the above debts. Now let us first form the COC. So let us again go back to Excel. So Excel sheet is there. So this is the sheet we were using. So here, let us say constitution of COC. So there is one A, then B. तो और कौन कौन है उसमें? C,
बस
D
A and B रहेंगे सर, C नहीं रहेगा क्योंकि वो रिलेटेड पार्टी में आ जाता है.
कोई बात देख लेते हैं. C, ये तो C है खाली. फिर ये D हो जाएगा और फिर ये E हो जाएगा. तो अब A जो है, A के पास 200 है और B के पास कितना है? 250. ठीक है. तो एक का शेयर कितना हो जाएगा? इसका परसेंटेज शेयर, परसेंटेज भी आपको असाइन करनी है. सो परसेंटेज शेयर विल बी 200 divided by 450 into 100. So it will be 44.4%. 44%. है ना, ये आएगा ना, और ये आपका आ जाएगा 55.66%, 55.56%। तो ये तो हो गया। अब नाउ अनदर पॉइंट इज, अब और थोड़ा सा और देख लेते हैं, लेट अस सी this fact also. So here C will not be counted because C is a related party. But D and E are operational creditors. So they together, they have 400 lakhs. So 400 lakhs out of 1000 lakhs. So whether it is anyway affecting, suppose because operational creditors, they are constituting 40% of the entire debt, 40% of the debt. So whether they will be invited to the meetings of the COC or not.
So they can come to the meeting, as in one authorized representative can represent all the operational debtors.
Yes. So here, so they have given two types of operational debt, D and E. So whether one out of D and E will come or two can come. And when calculating this 40%, so we have calculated 40%. So this 40% has to be calculated on 1000, or we have to exclude this related party debt. This is another question.
Okay.
Now
So
let us
we
see the
will-
section. Let us see the section. Best way to read is to go to the section instead of straight away answering. So this will be given in section, which section?
So Committee of Creditors, section number 21.
Section 21. So section 21 says, now this fact of 10%, where it is written? Or it is given in regulations? Let us see the regulations also. Constitution of committee, it is given in regulation number 17. Rather we can to see committee with only operational creditors. So any idea with respect of 10% of debt is written? I think the answer can be found in section 24, meetings of the committee of creditors. Let us try to find it here. So it is when we read this section 24, subsection 3, subsection C, it says the resolution professional shall give notice of each meeting of the committee of creditors to operational creditors or their representatives if the amount of their aggregate dues is not less than 10% of the debt. And debt here means total debt. The directors, partners, and one representative of operational creditors, as referred to in subsection 3, may attend. So there will be only one representative of operational creditors. And another question which I asked, so this is given in section 24. So section 24 talks of this. So this was question number 7. So section 24, subsection 3, subsection C. And second question which I asked was whether this 10% is to be calculated with taking the base amount as 1,000 or 850. Any idea?
1,000.
1,000. Yes. It says not less than 10% of the debt, basically. And for debt, we have to see the definition of debt. And what is the definition of debt? Debt is defined where? In section 3. Because when you go to NCLT, there is a debate on each and every word. So debt means a liability or obligation in respect of a claim which is due from any person and includes a financial debt and operational debt. So both are included. So even a claim of a related party will be a debt. That is the meaning, basically. So due to impact of heavy losses and liquidity crunch, the XYZ Limited could not pay the above debt since the debts were overdue. Creditor A filed an application to initiate. So who will form part of the COC? So we have seen that A and B will form part of COC. Whether the above operational creditors have a right to vote,
No.
whether they have a right to vote or not,
No, sir.
No, sir.
they don't have any right to vote. But they will be
Part of the
yes.
meeting.
So they shall be given notice of meeting. So what is the compulsory agenda to be discussed in the first meeting of COC?
Appointment of RP.
Where it is written?
Section number 24, Committee of Creditors.
So where it is written that he has to discuss these things?
Give me 1 minute, sir.
Section 22, subsection 2.
So section 22 talks of the appointment of RP and it talks of the first meeting. So the committee of creditors made the first meeting by majority vote of not less than 66%, either resolved to appoint the IRP as RP or to replace. So this is the compulsory agenda. So compulsory agenda is this. It is given in section 22, subsection 2. So you can go on writing the sections also so that you can remember these things. Now, what shall be the quorum of the COC meeting if it is conducted through video conferencing? So what shall be the quorum?
33%.
33%. So quorum is 33% only, whether it is conducted through video conferencing or physical or a hybrid mode. Because some persons may be available physically. And next question, I think that is the question here. So in this case, who should attend the meeting? Because we have seen the parties, because only A and B are members of COC. So if only A attends, whether quorum is complete?
Yes.
Yes, sir.
Yes, because it has to be seen by vote share. So vote share is 44%. So Quorum is complete. Now next question. SLX International Limited, a foreign trade creditor. So whether a foreign trade creditor can initiate an application and by which section it is governed. So where it is written that foreign trade creditor can file an application? Because it is a foreign company, SLX International Limited.
They can file a claim, but I'm not sure about the section.
No, here they want to initiate the petition under section 9. So the question here is whether a foreign company can initiate this CIRP petition under section 9. This is the question.
Yes, sir, they can.
If they have business connection or a branch office in India, sir.
Okay, where it is written, you have to support it by the exact section 9. Let us read section 9, what it says. So it says, after the expiry of 10 days, if the operational creditor, so he should be an operational creditor. So the only condition is he should be an operational creditor. He could be an individual, he could be an HUF, he could be a foreign entity, he could be a domestic entity, any. But suppose he wants to file an application against a foreign company. So can he do so? The company to which he supplied goods, that is also a foreign company. Then
why would he file it in India?
Yes, yes. So if there is business in India only, then they will file. Otherwise, there is no point. So the foreign company was not having any office or bank account in India. Because of this, it could not submit a certificate from financial institution as required under the code. Examine whether the petition is admissible. So whether this certificate from financial institution is essential or not?
No, sir, not essential.
Yes.
Section 9, subsection C.
Yeah. So earlier
Clause
there was a point, now it has been amended with effect from 6th of June 2018. When IBC came, this certificate was mandatory. But then there was a case of Macquarie Bank, and they said that, okay, we are a foreign banker, we don't have any bank account in India. So how, who will give a certificate? So it says by the corporate data, if available. So a copy of the certificate from the financial institution maintaining accounts of the corporate operational creditor, confirming that there is no payment of an unpaid operational debt by the corporate debtor if available. So if available, it's okay. If not available, there is no such condition.
Sir, why is it a fact that foreign trade creditor, if he's not a trade creditor, but if he's a financial creditor, cannot file it?
We can file. If he is a financial creditor, he still can file.
Okay.
They have only given the facts that he is a foreign trade creditor.
Okay, sir.
Even if he is a financial creditor, he can file the petition under section 7.
Sir.
Now let us see the next question. So I have marked them 8, 9. So this is 9th question now. Whether an operational creditor can assign or legally transfer any operational debt?
Yes, sir.
Yes, sir.
Section. Yes. So this assignment of debt is covered under which section?
Sir,
Regulation. I think it is covered in regulations. Transfer of debts due to creditors. Regulation 28. In the event a creditor assigns or transfers the debt. So this is given in regulation number 28. Now let us see the question. Whether an operational creditor can assign or legally transfer any operational debt to a financial creditor? The answer is yes. But which option is correct out of these?
So first option.
Option A.
Yes, however, the transferee shall be considered as an operational creditor. So even if he assigns the debt to financial creditor, so the character will not change. So that financial creditor will become an operational creditor to the extent of the debt assigned. So answer is A, right? Now let us see this question. Question number 10. Agenda. Which of the following agenda items should be taken in the first meeting of the COC? So it is again given in
Option A.
regulation number, section number 20, कितना था वो? 22?
Yes, sir. 22.
हाँ, तो ये आपका आ जाएगा
Clause
section
subsection.
22 subsection 2. Appointment of IRP or replacement of RP. ठीक है. Preparation of draft resolution plan. No, it is not. Discussion of the status of the corporate debtor as of the present date and the roadmap ahead. Collection of information on corporate data from independent. So A is the answer. Now let us see the next question. So what is the quorum in case of meeting of committee of creditors? Out of this, which option is correct? These are the 4 options.
Option A.
Option A, sir.
So members of the committee representing at least 33% of the voting rights present either in person or... Now suppose people come, but they live in between. One person says that I have to attend a marriage. So what will happen?
Then the quorum will reduce because they have to stay in the meeting throughout the meeting, sir.
Yes. So they have to stay throughout the meeting. It's not that they join and then they leave in between. So where it is written, the quorum has to be present throughout the meeting. It must be written somewhere, no?
So give me one.
Regulation 22.
Regulation 22. So regulation 22 says now where it is written that they have to be present throughout the meeting.
So sorry, it is 24-4.
Right. So, right, this is correct. So 24-4, the resolution professional shall ensure that the required quorum is present throughout the meeting. So it has to be present. So they can ask questions like this. So 24-4. But answer here is A. But another question. When the meeting commenced, 50% members representing 50% of vote share were present. But members representing 10% of vote share, they left in between. Then what will happen? There could be this situation.
So, but it is still more than 33%. So there is no issue, I guess.
Okay. So let us read it again. What it says? It says, the resolution professional shall ensure that the required quorum is present. So basically, what is required is that the quorum is present. So quorum is 33%. Suppose initially it was 50% and then 10% left in between. So I think still the quorum is present. But if the quorum falls below 33%, then meeting cannot continue. This is the meaning. They can ask you questions like this also. So you have to be prepared. So So you have to read each and every question very carefully, and you have to think of the other alternatives also. This is just a hint that these could be the type of questions. These are asked in CA final examination. So Ram, the financial creditor, was an investor and a debenture holder of optionally convertible debenture bond, payable on maturity with redemption premium issued by Asset Limited Corporate Debtor. The zero interest OCDB bonds amounted to 3 crores. It was matured in 2016. The corporate debtor failed to discharge this liability on due date. Ram filed an application to initiate the CIRP. Now advise in light of the following whether Ram is eligible for filing an application. So Ram is a debenture holder and is holding optionally convertible debenture bond. And the amount is 3 crores. So whether Ram is eligible for filing an application and what are the sections we will see when we are looking at this situation. What are the sections we will see?
7.
First of all, we will see the definition of debt. We will see the definition of financial debt.
5 subsection 8.
So first of all, let us have a look at section 5 subsection 8. So section 5 subsection 8 talks of financial debt. So where it will be covered? In section 5 subsection 8? It will be covered in 5.8c. Any amount raised pursuant to any note purchase facility or the issue of bonds, notes, debentures. So debentures is covered in 5.8c. So this will be covered because you have to pinpoint everything. So this will be given in section 5 subsection 8 subsection c. Now second question. What other section you will look besides section 5 subsection 8?
So section 7 for filing application.
Oh, that is okay. And any other section? Whether section 21 also we will look or not? Because section 21 also talks of a class of creditors. So let us have a look at section 21 also. So section 21 6A, where a financial creditor. So I will draw your attention to section 21, subsection 6A, subsection A, where a financial debt is the form of securities or deposits, and the terms of the financial debt provide for the appointment of a trustee or agent to act as authorized representative for all the financial creditors. Such a trustee or agent shall act on behalf of such financial creditors. So there could be, say, 100 debenture holders. So if there are, say, more than one, although it is not clear in the question, maybe that is the only debenture holder. So if he is the only debenture holder, then we don't have to look at this section. But otherwise, we can look at this section 21, 6A also. Whether the redemption of debenture bonds payable on maturity debt amounts to debt.
Yes, sir.
Yes, so it is a debt. Now who can file this application? This Ram can file the application. But suppose there are, say, 100 such debenture holders. Then how many have to file?
Only one's a debenture trustee.
Gopal.
Yes.
বলছি
So such a trustee or agent shall act on behalf of such a financial creditors. Right. Right. But whether they will become a class of creditors in that case or not.
Yes, sir.
Suppose we change the facts of this question and we say that, okay, there are, say, 100 such debenture holders. So whether they will form a class or not.
Oh, yes, sir. More than 10 would form a class.
No. But it is saying is owed to a class of creditors other than the creditors covered under clause A or subsection 6. But that is talking of appointment of AR. So in this case, appointment of AR is not. So another related question, whether appointment of AR is needed in this case. Suppose there are, say, let us change the facts, and there are, say, 100 such debenture holders. So whether the appointment of AR will be needed here or not. As you know, in the public announcement, you have to give the name of the AR. So whether in this case, you will give the name of the AR or not. What is it?
There are 100 debenture holders. In that case, we will just take the debenture trustee, no?
Right. So this will be governed by trustee or agent. He shall act on behalf of. So there is nothing is to be done regarding this AR part. So AR will be done only when is owed to a class of creditors other than the creditors covered under clauses. So clause A creditors are not covered as far as the appointment of AR is concerned. Or subsection 6. So 6 talks of this consortium funding, etc. So similarly, in case there is a consortium funding and suppose there are, say, 10 financial creditors. So suppose there are 10 banks or there are, say, 20 banks who have financed a CD. So whether those 20 banks will form a class of creditors? This is the question. No, the answer is no. Because in that case also, the appointment of AR is not needed. Every bank can appoint his representative and they will be considered individually. So that is why you have to read this section 21 also very carefully. Now let us see the next question. So I think we are able to discuss some of the concepts through this.
Yes.
Now let us see this question. Which of the following is not covered under the definition of financial debt out of these 4?
Point B, market value for derivative taken on.
I guess B, sir, yeah, actually.
Let us see
D.
5 subsection 8. I think the best way would be to see section 5 subsection 8 and let us try to identify under which clause each one files. Number 1, interest on unsecured debentures issued by a corporate debtor. So where it will fall? It will fall in 5.8c. Market value of a derivative. So market value of derivative will fall under
G.
5.8g. So this is also a financial debt. Amount raised from an allottee of an apartment under a real estate project. So 5.8f. So this will fall in 5.8f. So all these are financial debts. Now let us see D. Receivables assigned to a bank on without recourse basis.
We did this on the
E.
first day.
So it says sold on non-recourse basis. So receivables sold or discounted other than any receivables sold on non-recourse basis. So if they are sold on without recourse basis, yeah, on non-recourse basis, so they are not covered. Only other than receivables sold on non-recourse basis are covered. What is the difference between recourse and non-recourse? Any idea? Anyone can explain this?
Non-recourse means you can't, the buyer cannot again go back to the seller.
Yes.
If
So
there's a default.
non-recourse means that because basically this is factoring. So in this case, if the ultimate person who was responsible to pay doesn't pay, then the banker cannot go back to the person for whom this discounting was done. But if it is sold on a recourse basis, so that means he can take action. This is the meaning basically. So D is not covered here. So what is the answer? D. D is the option. Now, the IRP appointed for multi-crop is seeking your views on the constitution of the COC of multi-crop. Multi-crop doesn't have any financial debt other than a loan obtained from Mr. Ajay Jhawar, son of Mr. Vijay Jhawar, the managing director of Multicorp. So the only financial creditor is the son of MD of the CD. So considering the above, identify the appropriate constitution of the committee of creditors out of the following. So out of these four, what will be the right constitution?
The B. 18 largest operational creditors, 1 representative of workmen and 1 representative of employee.
Okay. What about D?
And resolution professional, but option D talks about 18 largest operational creditors, 1 AR of workmen and 1 AR of employees and RP.
So what is better out of B and D?
No, but it is given that the RP is a part of COC. But so I guess B, sir.
Yes, B is the correct option. Right. So 1 crore जीत गए आप. So B is the correct option. 18 largest operational creditors, 1 representative workman and 1 representative of employees. Which section? सेक्शन कौन सा? अभी तो देख रहे थे ना हम लोग. So section is 21. Now here, let us see. In view of the deep recession prevailing in the market for the past 3 years, Infra Limited, which was facing the brunt of financial crisis, could not pay. So let us briefly summarize the facts. In this case, the trade union is filing the application on behalf of operational creditors. So the basic question is whether trade union can file the application on behalf of operational creditors or the operational creditors themselves have to file. This is the question, basic question. Any idea on this?
Yes, so the trade union has been notified as a person and they can file as operational creditor when there are a lot of applications under operational creditor from the workmen. There was this Jawahar Mill जूट केस, ऐसा एक कंपनी का केस था, तो उसमें ऐसी बात की गई थी जिसमें ट्रेड यूनियन को पर्सन के डेफिनेशन में डाला गया था.
Right. So you are correct. So they can also file the application. So if it is a registered trade union, they can. Okay. So now, what will be the initiation date? And what is the initiation date in case of in case of CIRP? What is the initiation date?
So the date on which application has been submitted to the adjudicating authority.
Yes. Complete in all respects.
Just one question over here
Yes.
on this workers and employees. A worker has, given a claim, but then
Okay.
he resigns from the company and he takes up a job elsewhere,
Okay.
but his due is not settled.
Yes.
Can he still file a claim?
Yeah, why not? He will definitely file a claim. Even
But
if
he is no longer a workman or employee of the corporate
no,
debtor.
no. Actually, the claim has to be filed as on the insolvency commencement date. As on the insolvency commencement date, he must have been the employee now. Or even there could be a case. Suppose a worker left the company, say in July say 2020, and this application was admitted say in December 2020. He has already left the company, but there are dues, so he is an employee.
It is not necessary that he has to be employee at the time of filing the
No, it is not necessary, but only the dues should be payable.
dues will be there because
Yes. So naturally, an ex-employee is also covered.
ex-employee is also covered.
Yes. Normally, when you are not paying salary or wages, so who will remain in the company? They will all leave.
Yes, yes.
So naturally. ऐसा तो नहीं बोल सकते ना भाई सैलरी भी नहीं देंगे और काम भी करना पड़ेगा ऐसा तो नहीं हो सकता
No, but it is not mentioned anywhere. That's why I was, neither in the regulation or in the act, it is not mentioned that ex-employees, ex-workers can also file a claim.
It is saying operational creditor. So it is not a question of employee. So it's an operational creditor. So
Yes, on the books he is a creditor.
Yes. So
On
he
the
has to
books
be
of
an
account, he is
operational
a
creditor
creditor.
now because he provided services to the company. So he's an operational creditor. So who can file an application? Application can be filed by the operational creditor. The question is whether he is an operational creditor. The answer is yes. And for this, you can refer to the definition of operational creditor. Let us see. So operational creditor definition, where it is given? It is given in section 5. So section 5 talks of operational creditor. And what it says, a person to whom an operational debt is owed and includes. So there is a debt owed to him, no? And includes any person to whom such debt has been legally assigned. And operational debt means a claim in respect of the provision of goods or services, including employment, or a debt in respect of payment of dues arising under any law and payable. So there is a debt due, no? So definitely he is covered.
So he will file a claim as a OC and not as a workman or employee.
Definitely, because actually there are different forms for employees and other operational creditors. That is the only difference. There is a difference in the claim form only, but otherwise both are operational creditors. Because employees can file a claim individually or even a trade union can file on behalf of all the employees. So there are different forms, I think D and E. So you can check the exact form, but I think these are the forms which are applicable for this employees and workmen. So if you see the insolvency, so form A is public announcement. Form B is proof of operational creditors by except workmen. Operational creditors except workmen and employees, they were to file form B. Then form C is by financial creditors. Form CA by financial creditors in a class. Form D is for workmen or employee. And form E, the authorized representative of workmen and employees. So these are the different forms only, but all are operational creditors. Now let us see the next question. The Committee of Creditors of Messrs. XYZ Limited proposes to appoint Mr. Ajit, an insolvency professional, as an IRP in the matter of CIRP of XYZ Limited. So they want to appoint Ajit. Ajit was a promoter of ABC Limited, which is a holding company of XYZ Limited. So Ajit is a promoter of ABC Limited, which is a holding company of XYZ, which is into CIRP. Now, whether Ajit is eligible or not, this is the question. So we have to see the regulations for this. And what is the related regulation? The related regulation is appointment of professional. So regulation number 3, eligibility for resolution professional. So the question here is, a person shall be considered independent of the corporate debtor if he is eligible. So far, he is not a related party of the corporate debtor. So whether he is a related party of the corporate debtor or not, this is the first question.
It's a holding company.
And he was the
Promoter.
promoter of holding company. So the question here is, we have to see the relationship of Ajit. So let us go to section 5, subsection 24A first. So section 5, subsection 24A, what it talks of? Let us see. Section 524A, because we have to see the relationship of Ajit. And 524A talks of related party in relation to an individual. So a public company in which the individual is a director and holds along with us. So whether it is covered anywhere or not, any idea? So you may not find the answer here. But in this case, what you will do, you will go to the definition of independent director. So I think we have to explore this point. A person shall be considered independent of the corporate director if he is eligible to be appointed as an independent director. Now the question here is whether he can be appointed as an independent director of XYZ Limited. This is the question we have to see. And where it is given? It is given in section 149. So let us see section 149 of the Companies Act. So I'll take you to my site, cirkgupta.com. So here you go to Knowledge Bank and then you go to Acts and Corporate Laws and Companies Act 2013. And then you have to see section 149. So section 149 will be covered in कहाँ जाएगा आपका ये चैप्टर 11 में आएगा क्या चैप्टर 11 में देखते हैं एक बार यस so company to have board of so this is section 1 I think this screen is visible on your screen है ना नजर आ रही है आपको
yes sir
तो 149 में आप देखो अब ये इंडिपेंडेंट डायरेक्टर की वहां कहां बात करता है कौन सा सबसेक्शन है इसका 149 का an independent 149(6). So you have to see section 149 subsection 6. So it says who is or was not a promoter of the company or its holding. So promoter एक तो यहाँ आ गया promoter. अब ये promoter तो नहीं है ये कौन है ये promoter है क्या holding company का है ना
हाँ सर
yes sir yes
promoter है holding company का
हाँ तो यहाँ पर कवर हो गया आपका 149(6) में कवर हो गया So the question here is whether promoter of a holding company can be appointed. The answer is no. So it is covered in section 149, subsection 6, subsection B1. He was or was not a promoter of the company or its holding subsidiary or associate company. So you have to clearly see all these clauses. So बहुत लंबा section है ये 149(6) और इसमें से they can ask you questions. कोई भी question पूछ लेगा. ये सारे इसके अंदर आते हैं. Dubara, let us go to. So in this case, whether he can be appointed or not, he cannot be appointed because he is covered. He cannot be appointed as an independent director. बस एक दो क्वेश्चन और ज्यादा नहीं Now let us see this question. Abhi Limited entered into an agreement with Atulya Gas Limited for purchase of natural gas, which is not specified as an essential supply. So it is not an essential supply. On failure of Abhi Limited to make payments, Atulya Gas Limited issued notice to Abhi Limited that further supply of gas would be stopped if payments are not made immediately. On further non-payment, Atulya Gas Limited filed a petition before NCLT for initiating corporate insolvency resolution process against Abhi Limited. Now this Atulya Gas Limited is financial creditor or operational creditor?
Operational credit, sir.
Operational creditor. Yes. On 15th March 2020, the petition was admitted. On 30th April, Atulya Gas Limited disconnected gas supply. So the application was admitted on 15th of March. So moratorium is effective from 15th of March. And then during moratorium, they have disconnected the gas supply for non-payment. As a result of disconnection of gas supply, operations of Abhi Limited came to a halt. The resolution professional filed a petition to NCLT seeking Atulya Gas Limited to resume the supply of natural gas, as natural gas was an important material for production of electricity by Abhi Limited. So now, when the moratorium period will expire in this case? So when the moratorium period will come to an end in this case?
So on approval of resolution plan or ending of 180 days.
Right, right. Or any extended period. Now another is, can this Atulya Gas Limited disconnect the supply? Because
So
the
yes, sir.
matter has gone to NCLT now. The resolution professional has filed a petition to NCLT seeking Atulya Gas to resume. So if you were an adjudicating authority, what direction you will give?
So
You have to make a distinction between the dues up to the insolvency commencement date and dues thereafter. So dues up to the insolvency commencement date can be claimed through a claim form. So he has to file a claim. Atulya Gas Limited has to file a claim in respect of dues up to the insolvency commencement date, which is 15th of March. But dues thereafter have to be cleared. So if so long as current dues are cleared, so they cannot disconnect the supply. But suppose even the current dues are not being cleared, then they can disconnect the supply. This is the question. And this is given in section 14. So section 14(2), I think, talks of this. So section 14 says, section 2A, section 14(2)(a), where the IRP or RP, as the case may be, consider the supply of goods or services critical to protect and preserve, then the supply of such goods or services shall not be terminated, suspended or interrupted, except where such corporate debtor has not paid dues arising from such supply during moratorium period. So this point is also clear. 14(2)(a). Now let us see the last question. Now XY Limited filed a petition under IBC with NCLT against DF Limited corporate debtor, and the petition was admitted. So there were only 3 financial creditors, including XY Limited. Okay. So there are only 3 financial creditors. So the corporate debtor have settled the claims of all the 3 financial creditors. Whether such settlement agreement could be termed as a valid resolution plan. Also discuss whether a financial creditor in respect of whom there is no default can file an application before adjudicating authority. So there are 2 points here. Number 1, CD has settled the claims of all the 3 financial creditors. So whether such settlement agreement could be termed as a valid resolution plan? Any idea?
no, sir, this is not a resolution plan
Yeah.
because corporate.
Right. So actually COC has to agree to withdrawal application. So CIRP once commenced, even if payment is made, will continue. So they cannot say that either the financial creditor will approach or the CD will approach that okay, we have made the payment, and because there could be question as to interest and so many other things. Right? So we have to see that we have to go as per section 12A only. So CIRP once commenced, so it can be done only through the withdrawal application, withdrawal mechanism that is given in section 12A. And regarding this, suppose there is no default. So whether a person, suppose there are 3 financial creditors and there was a default in respect of say financial creditor A, but can financial creditor B file the application for whom there is no default? So here the answer is that default and filing the application are 2 different things. Number 1, as soon as the default is there, as per section 4, the IBC is triggered. So IBC provisions are triggered as soon as there is a default. And section 7, we have to see for filing the application in respect of financial creditor. So section 7, what it says? Section 7 says a financial creditor either by itself or jointly with other financial creditors or any other person on behalf of the financial creditors may file an application for initiating corporate against a corporate debtor before the adjudicating authority when a default has occurred. So whether a default has occurred, yes. So financial creditor can file the application. So it is not necessary that the default should be in respect of the same financial creditor who is filing the application. But it is not so in case of operational creditors. So I think this much is sufficient for today. So we discussed all the questions related to CIRP in today's section. So next class is on Friday, and in next class we will start with liquidation. In the meantime, you can go on studying the various study material which I have given. You can discuss in the group also. But from Friday onwards, we'll take up this liquidation process.
Okay.
Any questions if you have, you can ask. Okay, good night.
Thank you, sir.
Thank you, sir.
Thank you.
Thank you.